Yes. Have you ever encountered police on the road and they have been trying to conduct search on you? Or have you ever been reported by a complainant to any security agency and they have approached you or approached your premises to conduct search? So if that has happened to you, today's program is for you. Please stay connected on our program as we are going to discuss search today by the security agency on the people. So we are going to look at the search of people or search of persons, search of a person, search of premises. So please stay connected as we are going to look at this accordingly in this program. So search is conducted on a person that is suspected to be in possession of an unlawful thing in order to be used against him in trial. So why police conduct search is that maybe before you will be searched, then there is a presumption that you are in possession of an unlawful document or an unlawful property or something that is unlawful, or police is suspected that you that are about to be searched must have committed an offense, and police or any security agency is engaged on that search in order to obtain evidence from you in order to be used against you in trial or in order to be used during the trial of that case. So the question is, who conducts search? It is the police or the law enforcement agent that is investigating the crime that has the right to conduct search, and this is usually done after the arrest, not before the arrest. So the person that is responsible, the person that has the legal right to conduct search on a suspect or someone that is suspected to have committed the crime, is the police officer or the law enforcement agency designated to investigate that particular crime. So on this edition, we are going further to look at search of a person. So we are going to look at what is called search of a person. Please stay tuned as we are going to discuss this serially in our subsequent edition. So we are going to look at search of a person. Under the Administration of Criminal Justice Act 2015, operational in FCT, Federal Capital Territory, Abuja. Yes, under the Administration of Criminal Justice Act, operational in FCT, Federal Capital Territory, Administration of Criminal Justice Act, operational in Abuja, expressly stated that a person should be searched by a person of the same sex, and the search must be conducted with decency. So that is the law. So before you search a person, you must be of the same sex with that person, and in conducting that search must be conducted with decency. So that is what the law provides. Now we are going to look at search of a premises. Now, if you want to conduct a search on a premise, that search must be conducted in the presence of the occupant and also in the presence of witnesses. So if any law enforcement agent wants to conduct search in a premises that has occupants, that search must be conducted in the presence of the occupant, and there must be witnesses. At least not less than 2 adults must be there to witness the search. And another important rule is that the person that is conducting the search must be searched first before he engage in the search. What I meant by that is that if a police officer wants to conduct search in your environment, that police officer must be searched first before he conducts the said search. So the reason behind this principle is that so that the person, the occupant, will not allege that it is the said police officer or the searched agent that implanted those incriminated items. So that is why it is paramount and is also the law that the searcher must be searched first. That is before the security agent who intends to search the premises, search that same premises, that person must be searched first. Then just know the rule. The second is that the occupant must be what? Must be present. And also witnesses, no less than 2 from the environment must be present before such search will be conducted on the premises. Another thing that is very important for us to note in this edition is that when a premises is to be searched, it is required of the police officer or the said security agent to come with a search warrant. But another principle is that any police officer that is in possession of warrant arrest does not require search warrant. Do you understand what I'm saying? So the principle, the law is that before a premises could be searched, it required a search warrant. But when a police officer is with warrant of arrest, remember, warrant of arrest is different from search warrant. Search warrant is a document, is an authority mandating the security agency to search a premises, while warrant of arrest is an order directing or empowering the said police or security agency to arrest a suspect. But look at it now. If you are to conduct search on a premises, the police officer is required to have a search warrant. But when the said police officer is having search warrant, he is not under obligation to obtain another search warrant if he has warrant of arrest. Because the law is that when the police has an information that the suspect is hiding in a particular premises and he is giving the warrant of arrest but not warrant of search, so that warrant of arrest will cover him to conduct the search and to arrest the suspect. So that is the rule. And in that situation, you will not be given the opportunity of searching the police first, because what is anchored of is to arrest. It then means that there is an information that there is a suspect in that premises. So therefore, he will first do the arrest before he will engage in search. In that situation, search warrant is not needed. So another thing that we are going to look at is, how do you know the eligibility of search warrant? Not that it's a document is shown to you and you will accept it that is a search warrant. How would you identify a search warrant? One, the search warrant must be signed by a magistrate, or it must be signed by the issuing authority. If it is issued by police, it must be signed by superior police officer, senior police officer. Then, secondly, the warrant of search must indicate clearly, must describe clearly the premises to be searched. For instance, if in the warrant of search is indicated that the premise of number 17 Ademola Adetubo Street, Wuse Zone, Wuse 2 is to be searched, and the officer went to number 3 Ademola Adetubo Street, Wuse Zone 2, you now say that that's not the proper place to be searched as indicated in the search warrant. So what you need to do when you are confronted with search warrant is that you look at the following features. One, is that search signed by a magistrate or the issuing authority? Two, does it have proper description of your premises? Does it give the detail of your premises? Is the address stated in the premises the same with the same premises to be searched? So these are the things, these are the features you will consider in the search warrant. Thirdly, the search warrant will itemize the item that they are looking for. It will indicate what they are searching for. But one of the rules is that if in the process of conducting the search, another thing is being found, despite the fact that it's not listed in warrant of search, and that particular thing is incriminating, the police or the security agency is not restricted not to seize those items, though despite the fact that it's not stipulated in the search warrant. For instance, when there is a search to be conducted in your premises with respect of a missing gun, or with respect of an item suspected to have been stolen, and in the process of conducting the search, it happens that they found Igbo or anything incriminating in your premises, or something that have been declared missing in your premises, the police or the security agency conducting the search has the power or the authority to seize that item, despite the fact that is not stated in the said warrant of search. So, when you see a date on a search warrant, it is not something that you should challenge it, because a search warrant can be issued and executed any day. It can be issued even on Saturdays or during holiday. But the execution of the search warrant can only the search warrant can only be executed between 5 a.m. to 8 p.m. Are you getting it? So whoever that's anchored with search warrant and is come to your premises by 3 a.m. or 4 a.m. or even 4:59 a.m., such person has violated the rule of the search warrant. That means that the process of conducting that search is illegal. So the time frame of which search warrants can be executed is between 5 a.m. to 8 p.m. But remember, if you are in Abuja, the Administration of Criminal Justice Act 2015 has made the execution to be done at any time of the day. So there is no time limit in Abuja as expressly stated by Administration of Criminal Justice Act. So the warrant of search can be conducted in FCT at any time. But in other states, the law made provision that the time of execution of search warrant should be between 5 a.m. to 8 p.m. All right, some people might just ask question that, could the police just stop you on the road and search you without search warrant? The answer is what is yes, because under Police Act, basically, particularly Section 4 of the Police Act, empower the police to maintain law and order. And in the process of maintaining that law and order, they have the power to arrest and to search, to conduct any search, to stop a vehicle and conduct at any time. So when you are stopped by a police officer on the road, especially your vehicle, and they want to conduct such search, the police officer at that point in time ought not to anchor himself with warrant of search, because they have the power to stop and conduct search at that particular time or moment. So they are empowered by law to conduct such search, to stop and conduct search at that point in time. So police has that right to stop and search your vehicle at any time on the road. So such search is not illegal, it's allowed by law under Section 4 of the Police Act. All right, so before we wrap up this lecture, we are going to look at the liability for illegal or unlawful search. Any police officer or law enforcement agent that engaged in an illegal search or unlawful search can be held responsible for damages in a civil suit. And on that ground, the civil suit under trespass can be instead against him. And when that is successfully proved, he can be held liable and the court can award damages against him for trespass. So that is the position for illegal or unlawful search, because it will be established that indeed the search he conducted in your premises was unlawful. And how could a search be unlawful? One, when the police officer or the law enforcement agent went to a wrong place to search. That is, going to a place to search different from the place that is indicated in the warrant of search. Secondly, when it comes before the stipulated time of search or after the time that is not permitted by law. Thirdly, when that search is conducted with malice. Fourthly, when he searched the premises without the warrant of search. In that situation, such police officer or the law enforcement agent can be held responsible for unlawful search. So, I still remain your host on Law Classroom on Court TV by AAA. So, if you enjoy this lecture, please don't keep it to yourself. Share it with others so that the information can go viral. Help others to know what you have known. Thank you and remain blessed. And you also should understand, also to know that this class is not a legal advice. You can contact your counsel or your legal advisor at any time. Thank you and remain connected.